Good afternoon, everyone. It's time for us to have the House Criminal Justice Subcommittee on a Wednesday afternoon, February the 2nd. If you would indulge me just for a moment, we'd like to ask the blessings upon this proceeding. Heavenly Father, we thank you for this meeting that we have this afternoon, and we ask for your blessings upon it as we do the people's business and serve you in Jesus' name, and amen. Emily, would you take the roll?
Representatives Beck, here. Curcio, here. Farmer, here. Griffey, here. Hardaway, Howell, here. Lamberth, Farmer. Moody, here. Russell, Sexton,
here.
Chairman Doggett. Chairman, you have a quorum.
Thank you, Emily. Members, do we have any personal orders? All right, I don't see any personal orders, so that's going to get us right on the calendar today. And item number 1 on our calendar today is House Bill 1646 by Vice Chair Hall. We have a motion and a second. Vice Chair Hall, you are recognized.
Thank you, Mr. Chairman and colleagues. Members, currently, an assault on law enforcement K-9 is nothing more than a destruction of property crime. House Bill 1646 changes all of that and moves it to a Class B felony. It takes the shackles off of the DA and allows the DA to hold the criminals accountable for their actions. The motivation behind this bill was a group of juveniles that ambushed a law enforcement K-9 in Bradley County named Joker. After being shot multiple times, having a portion of his jaw removed, with a blood transfusion, and put on a feeding tube, Joker, on his first day back on the job, apprehended 3 suspects. This bill is endorsed by the Tennessee Sheriff's Association, all 95 sheriffs, 250,000 positive responses on social media, 17,000 signatures from my district on a local petition, and overwhelming support across this great country. All the ingredients are here in this bill. There's absolutely no negatives. If you're pro-law enforcement, if you love animals, if you want to be a good steward of the taxpayers' money, House Bill 1646 is your bill. Joker will be the poster K-9 that will change legislation across our country. And with that, Mr. Chairman, I renew my motion.
Thank you, Vice Chair Hall. Chairman Curcio, I understand that you have filed an amendment on this bill.
Yes, sir, Mr. Chairman. Thank you for recognizing me, and I want to say thank you very much to the sponsor for bringing this bill. And I applaud you for bringing this. I understand the background, and certainly the community has rallied around this effort and around this service animal, who clearly is doing the state a good service in his line of duty. But with your indulgence, I would like to move. I've got an amendment coded 12809, and what this amendment seeks to do, it keeps all of the language from your bill completely intact, but it deletes Section 4 of the bill, and that is the section that gives it the ability to transfer a child of any age to adult court for the commission of the acts outlined in this bill. Transferring that child to adult court is something that we reserve to murder, typically. And I think it's interesting to note, and I know this was not, again, know exactly what your intention is here, but if you do the same thing to an officer, the child would not be bound over to adult court. And so we just always want to be careful that we keep that balance there between, the difference between an animal life and a human life. Certainly it's serious, but we want to make sure that we don't tip that scale to the point to where the animal life is now worth more than the human officer life. So with that small change, that's what the amendment would do. Everything else is intact on your bill, and I would move that to the committee and encourage your consideration.
We have a motion and a second. We're voting on Amendment 012809. All in favor say aye.
Aye.
The ayes have it. Now we are back on the bill as amended, and I want to thank Chairman Curcio for the amendment, and I imagine that you are okay with that, but I'll let you speak on that.
Thank you, Mr. Chairman. I do recognize that as a friendly amendment, and I ask to adopt. Thank you, sir.
Okay, do we have any further questions on the bill as amended? Question has been called on the bill. All in favor say aye. Aye. No. Ayes have it. Bill goes on to criminal subcommittee. Excuse me, criminal full committee.
Thank you, Mr.
Thank
Chairman.
you.
Colleagues, thank you.
Okay, that'll bring us to item number 2 on your calendar, which is House Bill 1459. Vice Representative Hakeem, you are recognized. You have a motion and a second.
Thank you, Mr. Chairman and members. This bill deals with domestic violence and violence in the home. And as a statistical piece to this, looking at 2020, the year 2020, in the state of Tennessee, there were close to 70,000 instances of what we call domestic violence. Anything from murder, some of those things that really stood out was aggravated assault and simple assault, which were the majorities. What this legislation seeks to do, I guess you could use the term giving the magistrate or judge another tool in their toolbox. With the pandemic, I use the term tempers have flared, maybe more, and in a home, and violence takes place. And what we're trying to do is afford a cooling off period for those persons in the home. And that person who was the aggressor, the magistrate would have the opportunity to instruct that person not to go back into that home for 24 hours, affording that cooling off period so that we can avoid some of the worst things, in particular, murders. And I would mention that Tennessee was ranked number 4 in the nation when it comes to murder after domestic violence. Now we're at number 9. And I could hope that we continue to go down that ladder so that we're not one of the leaders when it comes to murder after domestic violence. And we do have an amendment, sir.
Thank you, Representative Keene. If you would go ahead and give us the barcode number of the amendment.
11007.
I have a motion. Do I get a second? I've got a second on that. All in favor of adopting this, say aye. Aye. The amendment is adopted and it goes on to the bill. Any?
No, sir, the amendment makes the bill.
The amendment makes the bill.
And basically what we're doing, instead of saying that the judge and magistrate shall do X, Y, and Z, it will afford the judge the opportunity by saying may, leaving that judge or magistrate in the position of making that decision.
Thank you. Representative Griffey.
Thank you, Mr. Chairman, and maybe this is a question for legal. I just wanted to clarify that this is adding an additional provision for the judge or the magistrate to say that they can impose a 24-hour hiatus, if you will, that a person cannot be at the location or the domicile of where the offense took place. But I thought that was already a ability that the judge could already do. I just wanted to clarify that, please.
Okay, with that objective, we're going to go out of session and we'll ask legal to respond.
Michelle Fogarty, Legal Services. Under current law, under 4011-150, the magistrate may already order a defendant to vacate or stay away from the home of the alleged victim. It doesn't give a time frame. It's up to the magistrate's discretion as to how long he or she wants to order that. But under current law, they can already order the defendant to stay away from the home of the victim and any other location where the victim is likely to be.
Follow up, Mr. Chairman. And so this bill would
Representative Griffey.
add a provision where the magistrate, is it shall or may, up to 24 hours or longer?
Under the amendment, it says may, up to 20. So actually, this language says may up to 24 hours. That would put that language in 3913-111, whereas under 4011-150, it says the magistrate may order the defendant to vacate or stay away with no time limit.
So that's the point I wanted to clarify. So this bill, if passed with the amendment, the magistrate could only order a person to stay away from the domicile for a 24-hour period maximum.
As written, the language of this bill says that they may order them to stay away or vacate from the place where the victim resides. Yes, 4011-150 applies to stay away from the home of the alleged victim and to stay away from any other location where the victim is likely to be.
So this is putting a limit, a 24-hour limit, or that's what I'm trying to clarify. I don't want to restrict the magistrate's ability to make him stay away, the person stay away longer than 24 hours. And is this going to limit that is what I'm trying to clarify. Thank you, Mr. Chairman.
I believe the question that we have is, will this bill supersede what we already have on the books? So there's a little bit of discussion. If you
Yes,
give
sir.
us just a minute and let
Yes,
us
sir.
work through this. And maybe, Leader Lambert would like to speak on that.
When we're back on the bill, I would be happy to. As far as the legality issue, and this is to legal, I mean, this would be a newer version in a separate section of the code. And again, I don't want to go too far since we're out of session, but I think there would be some serious concerns from a legal standpoint as to whether or not this does supersede the much more lengthy prohibition against returning to that residence now. And while I can't have the deepest level of respect for the sponsor of the bill, I can't fathom he would wish to do that. But yes, I would definitely, from a legal standpoint, worry a bit that while it says may, it's in a separate section of the statute. If they only look at that statute, I would genuinely be concerned that someone would argue we have two competing statutes, one saying may do 24 hours, another saying may be a condition for the entirety of the term the case is pending in court unless the judge changes it. It creates a real legal problem, I think, but I will defer to the experts.
I believe it's the newer statutes take precedence, and also the more specific ones take precedence over the general ones. So by putting in the 24 hours, that is certainly more specific than what is currently in law in 4011-150.
If there's no more questions for legal, then we're going to go back into session. We are back in session. We're back on the bill, and I think Representative Keem has asked to speak. Go ahead, Representative.
If it's acceptable, Mr. Chairman, we'll take off notice at this time.
Representative Griffey.
Thank you, Mr. Chairman, and thank you, Representative McKean, for bringing this. I think I get your intent, and I think there's a way to fix what you're trying to do, is just say that if requested by a victim or whatever, the magistrate shall, at a minimum, order the person stay away from a domicile for a minimum of 24 hours, or not less than 24 hours, something to that effect, if that's what you're trying to accomplish. So I appreciate, it seems like the intent of the bill, and I would just encourage you to, work it and see if we can get where we need to get on it. Thank you.
Representative Keene.
Yes, thank you. We have and will continue to work through that shall and may, but prior to today, my understanding was there was a 12-hour limit on that, and so yeah, I got some more education today as to what is on the books.
Okay, if there's no objections, it's requested to take this bill off notice, and so if everyone's good with that, bill's been taken off notice. Thank you, Representative King.
Yes, sir, thank you.
All right, that brings us to item number 3. Item number 3 is House Bill 1766 by Chairman Howe. Chairman Howe, you are recognized. I didn't see you
Thank you,
come
Mr.
in.
Chairman. I snuck in the back way.
Okay, good. It's good
My
to have you.
apologies. I wasn't here for the roll call. I'm 3 bills in 3 committees at the same time, so it's been a little challenging.
You
but-
made it just in time. Thank you. You have a motion and a second, so you are
Okay,
recognized.
thank you very much. Mr. Chairman, I do have an amendment that makes the bill.
We have a motion and a second on the amendment. If you would,
Don't
give us
have an
the,
amendment? I'm being told I don't have an amendment, but I've got one in my packet here. I'm happy as things are if I don't need to run this amendment.
well,
And I'll just be glad to go to explain the bill if you'd like me to, Mr. Chairman.
well, that would be good. Just forget what he said about the amendment, and we'll just
Oh,
go
yeah,
straight to
yeah,
the bill.
sure. Forget I said that, folks.
Yeah.
I didn't say a thing.
He didn't mean it.
The bill came to me from the District Attorneys Association, and it seeks, quite simply, to close a loophole in state law. This bill adds the conviction of continuous sexual abuse of a child to that list of offenses that already requires a judge to revoke the defendant's bail immediately upon conviction instead of waiting till after the sentencing hearing. Very simple bill. That's what it does, and I'd appreciate a motion to pass.
Very good. Thank you, Chairman Harrell. Do we have any questions? We have a question. Chairman Curcio, you are recognized.
Thank you, Mr. Chairman. I move previous question on this bill.
Thank you, Chairman Curcio. If there's no objection, previous question's been called. All in favor, say aye. Aye. Opposers, no. The ayes have it. The bill moves on to Criminal Justice Committee.
Thank you, Mr. Chairman.
Thank you, Representative Chairman Howe. All right, item number 4, House Bill 1678 by Leader Lamberth. We have a motion and a second. Leader Lamberth, you are recognized.
Thank you, Mr. Chairman. Very straightforward bill. Currently under the statutes, if you commit robbery against someone with a fake firearm, it is the same as if you utilized a real firearm. To the victim, they know no difference in many of those circumstances. This would add that into the provisions for aggravated assault if it's any article used or fashioned to lead the victim to reasonably believe the article was a deadly weapon. So fake knife, fake gun, if you are threatening someone like that, it's assault. Unfortunately, under the current statutes, that's not the case. If we were to make this change, it would be.
Do we have any questions for Leader Lamberth? Question has been called. There's no objections. All in favor, let it be known by saying aye. Aye. Opposers, no. Ayes have it. Bill goes on to Criminal Justice Committee. All right, Leader Lamberth, you are also on item number 5, House Bill 1679. Motion, second. Leader Lamberth, you're recognized.
Thank you, Mr. Chairman. And last year, we passed some very good legislation, in my humble opinion, led by both you, Mr. Chairman, and Chairman Curcio. And one of those bills dealt with expungement. And we were very clear in this committee that we were creating an expungement opportunity, and several, that folks could take advantage of once. That there was not a repeat opportunity for that every 5 years. I mean, that's just not what we set up. There has been an argument going around in some legal circles that there may be an argument for that in the code that we passed last year. I don't buy it. I've not seen a judge that has ruled that way yet. But the first part of this bill just clarifies that we did not create an unlimited expungement opportunity. It's a one-time opportunity. There are instances in the statute where you could get 2 A misdemeanors or an A misdemeanor and an E felony, or even, I think, 2 E felonies expunged, but it's a one-time opportunity. That's always been the intent of expungement. So this cleans up the first part. The second part goes into an area that one of our fellow representatives, Representative Halford, brought to my attention while we were out of session. He had one of his constituents that had gotten a theft charge early in life, first-time offender, expungable type offense, exactly what we all envision when we think of expungement. And then much later in life, a decade later or more, had gotten a DUI. Bad decision, not a good thing to do, was convicted of that. But unfortunately, because there was a subsequent conviction for a non-expungible offense, the original offense, the theft, could not be expunged. This fixes that, and if you have a first-time offense that is expungible, just because you later get an offense or multiple offenses that are no longer expungible, then that first one you could still have removed. In this particular young lady's circumstance, the theft was keeping her from being employed. The DUI did not bar her from employment, but the job that she was seeking said, look, if you have a theft conviction, we're not going to hire you. So this would allow her or anybody else to be able to go back and expunge that first time. Not anything later, but just that first time offense. That's what the bill does.
Thank you, Leader Lambert. We have a question. Representative Beck, you are recognized.
Thank you, Mr. Chairman. Leader Lambert, if those roles were reversed, and got the DUI and then the expungable, is that still going to be the same case?
Leader Lambert.
Unfortunately, no. If you start off with offenses that are not expungible, you can't cherry pick kind of which ones throughout. I mean, that's a discussion we could have down the road on whether or not we want to go there. We never have before. We've always been, hey, if you're kind of early entry into the criminal justice system, that first time offense would be the one that is expungible. But if you start off with a high-level felony or a DUI or something that's not expungible, then later get something that is low level, you have kind of missed your opportunity as a one-time, first-time offender.
Thank you for the explanation.
Is there any other questions? Just a comment. I think this is a great bill. I don't want anyone to think that Leader Lambert is getting soft in his old age. He's just getting wiser. Thank you. So can we get a move and a second on this bill?
Second.
Previous question's been called. All in favor, let it be known by saying aye.
Aye.
Opposers, no. Ayes have it. That bill moves on to Criminal Justice Committee. All right, that takes us down to the last bill on the calendar today, item number 6, House Bill 1763, also by Leader Lambert. Leader Lambert, you were recognized. Second. Have a motion and a second. You're recognized.
Thank you, Mr. Chairman. And I know Chairman Doggett had responsibilities and was not able to be here with us today, but I'm sure he's watching on this. He invited all of us to go over and tour the TBI a few months ago, and I took advantage of that. I've been over there and toured their facility many times, but each time I learned something new about how we can best serve here. And in this particular tour, they were discussing the opioid epidemic and the number of fake pills that are out there on the streets that are being sold to folks, and unsuspecting to those folks, they think they are buying a specific type of pill, and that pill is many times laced with fentanyl or other extremely dangerous drugs, as well as potentially the drug that they thought they were buying that's dangerous. And it's all because they're able to legally possess pill presses. You can apparently order them on Amazon or other places, and you can legally possess that. This would make those pill presses, under certain circumstances, paraphernalia, which is what they are. I mean, they are drug paraphernalia. It would be a misdemeanor. It's not a felony. But the hope would be is that it diminishes the number of pill presses that are available out there, and it does make exceptions if someone has that for lawful means. So if someone's a pharmacist or some other reason why they have a pill press that is for lawful means, then obviously they would be exempt from this. But if you're out there churning out illegal pills, this would create a new criminal act for that.
Thank you for that description. We have any questions? I have one. You said, I can't remember how you said it, but you said under certain circumstances. Could you elaborate on that a little bit?
So the pill press specifically, it excludes legitimate businesses. It excludes wholesale drug distributors, anyone that's a pharmacist licensed by Board of Pharmacy, manufacturers of drug products. So if someone is legitimately engaged in that, they're excluded from all of this. And so all of those circumstances are excluded from this. It's only going to be those that are literally involved in the criminal activity that would be included. But we listed out several exceptions in this bill to make sure, and if anybody sees anything we missed, please let me know, that if anybody's lawfully utilizing these devices, that they're fine. We don't want to catch them up in a broad net. So we put several exceptions in there for that.
Yes, Chairman Farmer, you're recognized.
Yeah, thank you. And this may be for the sponsor or legal, but I'd say the sponsor may know the answer to this question. Have anywhere else in the code with regards to drug paraphernalia, have we named like weights, scales, smoking devices, straws and stuff? Or are we worried about we're getting in a situation to where, well, now we're naming a certain thing as drug paraphernalia where typically we haven't in the past, to where there could be an argument that if it's not named, that it isn't paraphernalia?
Leader Lambert?
I can do my best at answering that, but I think legal probably has that up, and I actually think it does list several of those in there as well, and it also has some kind of catch-all language. It's a great question, and Mr. Chairman, I appreciate you asking it. Mr. Chairman, if we could go to legal on that, I think
Yes.
there is a list, but I can't recall it off the top of my head.
Yes, we will go out of session. Legal, if you would, give your explanation.
Michelle Fogarty, Legal Services, 3917-402-12C does list things like metal, acrylic, glass, stone, or plastic pipes, but the language in the definition says drug paraphernalia includes but is not limited to, and then there's a long list.
Does that answer your question?
Yes, Mr. Chairman, thank you so much.
Any more questions for legal? If not, we'll go back into session. Any more questions on the bill? Leader Lambert.
Thank you, and I appreciate that question. I did not have something on the bill, but just a point of personal privilege here. I wanted to thank our legal staff. We're here at the bill filing deadline day,
Yes.
and I just wanted us to thank you guys. You're here in committee at the end of a long day, and y'all have been working diligently. Thank y'all very much.
Well deserved. Thank you. So the question's been called. I'm going to honor that. No objections. All in favor, say aye. Aye. Opposers, no. House Bill 1763 moves on to Criminal Justice Committee. So I see no further business for this meeting, so without objection, this meeting stands adjourned.